Tribunal in the matter of the king on the application of Chowdhury and the Upper Tribunal.
Yes, Mr. Malik.
My lady, my lords, I appear for the appellant this morning with Mr. West. My learned friend, Ms. Thielen, appears for the Secretary of State, who is the interested party. The Upper Tribunal, who is the respondent, is not represented.
No, quite.
Just a couple of housekeeping matters, I'm afraid. First, the copy of the Upper Tribunal's decision that you have in the core bundle is not very clear.
No.
That was the best copy that was available when the bundles were prepared, but we have obtained a better copy.
Oh, well, that's very good. Yes, it was very greyed out. This is better. Thank you.
Yeah, good. Secondly, you may have seen the reference to this court's judgment in Bassif in skeleton arguments.
Yes.
That was the judgment where this court considered the principles in Flannery and the duty to give reasons. Now, Flannery is not in the bundle. What it says is uncontroversial, but we have printed a copy.
You've got it just in case.
Yeah.
I've got thank you. I've got a housekeeping point which just I wanted your help on. We seem to have had all the bundles. We had two lots. We had 2 lots of core bundle and 2 lots of supplementary. I have told my clerk to bring down only the core bundle, which contains 191 pages, which is, I think, looks like the same as yours, and is a good professional bundle. We did have a much fatter one, which was. You're going to be referring only to this one?
Yes.
And likewise, the supplemental, which is 98 pages, I think.
Yes.
Right.
That's all that you need.
That's fine. Well, I won't tell my clerk he needn't bring down the other ones.
Yes. And our apologies for the earlier bundle. An email was sent to the court with a proper explanation as to
Don't worry. We ended up with good bundles, and it only misled me for about 10 minutes. So, compared with some cases, it's not bad. Right.
So the primary question before the court this morning is whether there is a disputable question that the exception in section 11A for Roman 3 of the Tribunal's Courts and Enforcement Act 2007 applies to the Upper Tribunal's decision.
Right, I'm sorry. Would you mind, because we're writing while I'm speaking, could you just go back and state the proposition again, or the question?
Yes. So the question
is it a genuinely disputable question? Is that what we're asking, or a disputable question?
I'm not sure if there is much difference. But
the statutory word is question.
Question, yes.
But it has been glossed by this court, particularly by Lord Justice Dingemans in LA, as disputable, which I think it's not his word. I think he picked it out of the Privy Council case law.
Yes, that's right.
And I can't remember whether it's genuinely disputable, but you're saying no difference.
But yes, he uses the phrase, my lord, is absolutely right, genuinely disputable. I'm not sure if there is difference. I mean, if the question is not genuine, it's not disputable. But that is the question before the court, whether the exception in section 11A43 of the 2007 Act applies to the Upper Tribunal's decision. And I shall seek to persuade the court to answer the question in the affirmative. So subject to any observations, what I propose to do this morning is to address you first on the law relating to the exception. I will then make some brief submissions as to the application of the law on the facts of this case and the decisions made below. And finally, at the end, I will address you on the 2 points made by the Secretary of State in the respondent's notice.
That's fine. You say that that's the decisive question. But it isn't necessarily the only question. Suppose you succeed on that.
Yes.
Effectively, you're only in the position that Mr. Justice Griffiths was in by way of assumption, and he still put you down. So I think you've got to say, perhaps this is covered in your structure, you just didn't
Yes.
identify it as separate. There's a whole raft of questions, well, there's two big questions, even if you succeed, which is where what happens next.
Yes.
Yeah, okay.
Yes.
But you'll cover that.
Yes. Yes, and those I think are the points made by the Secretary of State
Oh, I
in
see.
Respondents' notice.
Fair enough, I see, yes, I hadn't, if that's what you mean, then you have covered them, yeah.
Yeah. So
Right, off you go.
unless there are any issues, this is the structure that I will follow.
Yeah, okay.
So the law first, Lords, you have behind tab 1, section 11A of the 2007 Act. Milady and my Lords are familiar with the provision. You'll see that subsection 2 provides that the Upper Tribunal's decision refusing permission to appeal is final and is not liable to be questioned or set aside in any other court. Subsection 3, 3b provides that the supervisory jurisdiction does not extend to and no application for judicial review may be made or brought in relation to that decision. The exceptions are identified in subsection 4, and it provides that subsections 2 and 3 do not apply so far as the decision involves or gives rise to any question as to whether, and then you have 3 limbs. It's limb C that is an issue here. The Upper Tribunal is acting or has acted, Roman 2, in such a procedurally defective way as amounts to a fundamental breach of the principles of natural justice. So there are 2 matters that the court would need to consider. The first is the effect of the words in the statute, and secondly, the test that applies at the permission stage. Now, the authority that will assist you in relation to those questions is LA Albania. You have that authority behind tab 6 of the authorities bundle. And you'll see that you'll see a heading just above paragraph 30 of the judgment at page 118, the effect of the wording of section 11A. And if you look at paragraph 31, you'll see that the court identified the primary purpose of section 11A, said that it's sufficiently clear to change the scope of the judicial review from the second appeals test to a test that is more stringent in section 11A. You'll see that 5 particular points are then made at paragraphs 31 to 35. It's quite clear that there is jurisdiction to quash an Upper Tribunal's decision, but that is, of course, now subject to the exception. In other words, the High Court's jurisdiction is not excluded completely. Paragraph 36, you have the conclusion as to the effect of the words in section 11A. And it effectively limits the grounds on which the High Court may exercise its jurisdiction, and that is binding. And you will see that to that extent, the decision of Ms. Justice Saini in Oceania was endorsed.
I mean, I don't know how much this matters, but this was a as it were, a big picture case, LA Albania and so was OTR. It was basically a challenge to whether 11A was effective at all. So some of the more subtle points that we have to consider here didn't really arise.
No. Yes. But this is what the court said about the general effect of the words in section 11A and the judgment of Mr. Stasini in Oceania. You'll then see a heading just above paragraph 37, the test to be applied in determining whether the exception apply. And you'll see that it was common ground in that case, and it's common ground here, that a mere assertion that exception applied is not enough. And a party needs to show a genuinely disputable question that the exception applies. The genuinely disputable question is the test. So for the purposes of this hearing, given that we are at pre-permission stage, I need not to persuade the court that there is indeed a procedural defect in the Upper Tribunal's decision that meets the exception in section 11A. This is because we have not reached that stage. The question for the court is whether there is a disputable question that the exception applies. So the threshold to achieve at pre-permission stage is much lower than it would apply to a substantive judicial review claim.
Yes, so but forgetting the extra complication that of the appeal, if we were Mr. Justice Griffiths, we would be asking ourselves, is there a genuinely disputable?
Yes.
And your case is, if that is so, we are bound to give permission.
Yes.
But does that follow? Because if he decides there is a genuinely disputable question, that something's gone wrong in terms of natural justice, in this case, as you would say, a crucial document has not been put before the court, applying ordinary judicial review principles, he would say, I have jurisdiction, I'm not barred, but I nevertheless am going to refuse permission because I'm satisfied that the argument was not going to succeed in any event. Therefore, permission to appeal would have been refused by Judge Grohl. Sorry?
Permission for JR.
Yes. I think it's in stages. The actual question, the first question he's asking himself is, if I allow this to go to a full JR, it will not succeed. And the reason it will not succeed is that if Judge Grubb had seen this document, he would not have thought that the appeal would succeed. He thought he would have formed the view that the appeal could not succeed, so he wouldn't have given permission to appeal. Therefore, we don't give judicial review in vain, therefore, I mean, this is the point where you're probably going to come to your respondent's notice point, but it comes in naturally here. Therefore, it's not good enough simply for you to win on the disputable question about procedure point.
Yes. So no problem with that in principle, but subject to the submissions that I will make in due course. But it's relevant to recall the nature of the judicial review proceedings. The judicial review court is not an appeal court from the first-year tribunal's decision. It is not considering whether the first-year tribunal judge has made an error of law. That is the task of the upper tribunal on appeal. the decision that is challenged in the judicial review proceedings is refusal of permission to appeal, namely that the appeal has no real prospect of success. Now, it is possible for an appeal to have a real prospect of success, for an appeal to ultimately fail on merits in the upper tribunal after a full hearing. But that is not the question in my respective submission for the judicial review court.
What is not the correct? Surely a judicial review court, assuming it has jurisdiction, should not give judicial review of a refusal of permission to appeal if it is satisfied that the appeal had no real prospect of success. Because that would be, are you accepting that?
Yes, I do.
Okay, well then I'm not sure what
issue.
we're apart from.
No. Yes, so the question is whether the appeal would have a real prospect of success, as opposed to whether the appeal would ultimately succeed.
Yes, well, no, that certainly. That I get, yeah.
So the threshold is the threshold for grant of permission to appeal from the first tier tribunal to the upper tribunal is quite low. It's mere arguability whether there is a real prospect of success. And at the permission stage, the judge is deciding, if the judge has jurisdiction, whether the claim is arguable, i.e. it is arguable that the appeal has a real prospect of success. So it's a fairly modest threshold. It is not appropriate, and I'll address you on this in due course. It's not appropriate for the judicial review court to simply assume the function of the upper tribunal.
But I mean, that's true of anyone granting permission to appeal on considering whether to grant permission to appeal. That's what you're talking about. You decide whether it's arguable.
Yes.
It's a little bit more tricky where it's a pure point of law, because that's effectively binary. But still,
yes,
if you think it's a debatable point of law, whatever your views about it, you should allow it to go into a full hearing.
Yes.
Yeah.
So that's the test that, in my respective submission, the court will apply. Now, if you then look at page 120 of the authorities bundle, you'll see the analysis as to the upper tribunal's decision taken in that case, and why the court concluded that the exception did not apply.
Sorry, which paragraph are you referring us
If
to?
you look at paragraph 40 of the judgment, this is where it is said that the upper tribunal's decision was correct, the High Court's decision was correct. This is because the upper tribunal expressly recorded that he considered the application of permission to appeal could be considered on papers. He addressed 13 grounds of appeal advanced on behalf of LA and gave reasons in respect of each of them, explaining why they were not arguable. But that, in my respective submission, is not this case. Now, my learned friend seeks to rely on the judgment of Miss Justice Saini in Oceana. Can I take you to that judgment just to deal with the point that my learned friend makes? Oceana is behind tab 8 of the authorities bundle.
Yeah.
If you look at page 157, you will see a heading, the principles of natural justice or fairness. Now at paragraph 32, Mr. Saini provided a high-level summary of what fairness in process generally requires. And that includes right to be heard by an unbiased tribunal, and the right to be heard on the relevant matters. Of course, an oral hearing is not required. A paper consideration would be enough to meet the requirement. But what the second point that is made is that what fairness demands would depend on the context of the decision. So there is no issue with that paragraph. Now, if the tribunal refusing permission has not considered the application or grounds, then that, in my respectful submission, would be a breach of natural justice.
Perhaps I can mention now, just in case anyone wants to be thinking about it, it occurred to me that there might be an analogy with the case law on reopening appeals under 5230, where there have now been a variety of different cases. On the whole, it's very difficult, high threshold and so forth. But one of the cases which everyone, I forget if it's a real case or merely an example referred to in the case law, is where the judge has read the wrong papers.
Yes.
You see that referred to both in the Mariana case and one of the earlier cases. I think it is actually a real case where the judge was given an out-of-date pleading or something.
Yes.
Somebody might care to research that, but it doesn't really matter what the facts of the particular case were. That is an example of where you will reopen. Now, the test there isn't described as procedural defect involving a breach of the fundamental principles of natural justice, but it's pretty close.
Yes.
If that is a proper analogy, it's quite close to what you say happened here,
Yes.
apart from the fact that your papers the judge didn't read were submitted long out of time.
Well, I have a submission.
You'll have submissions about that in
Yes.
due course. But anyway, I threw out that analogy
Yes.
because at the moment I think it's quite a
Yes, it is.
pregnant one, and I want to just Taylor of the judge. Is it Taylor or I ought to remember from last time?
It's Thalen.
So Miss Thalen can have a chance to think about it.
Yes.
Perhaps Mr. West can see if he can find where it comes from. But
Yes.
anyway, there we
Yes,
are. Carry on with your point.
Yes. So the submission is that if the judge has not read the right papers, then that plainly would be a procedural defect.
Well, it depends. It depends, doesn't it?
Well,
it doesn't it depend?
Well, on the, I would accept.
Well, it depends on what the judge hasn't read.
Yeah. Yes. On the merits, I agree. So if there is a document that puts forward a ground that is hopeless or it has no prospect of success.
Well, it surely depends upon the significance of something. In this case, we're talking about judges not reading things, but the significance of what isn't read for the fairness of the decision as a whole.
Yes. So what I meant, I do apologize, is that if the judge has not read the grounds of appeal, the grounds on which he is asked to.
But even that depends. I mean, let's suppose it was a case in which there were 7 grounds of appeal.
Yes.
And then counsel coming into the case anew thought of a possible 8th ground of appeal and put that in, and it never reached the judge. Well, I mean, the calculation would have to be what was the significance for the intended 8th ground of appeal for the whole picture. I mean, one can't simply say because somebody comes up with an argument that they could have put in as a ground of appeal that will automatically lead to this being fundamentally procedurally unfair. Can one?
Well, if yes, I mean, if a party has put forward a ground, then the duty of the judge is to expressly engage with that ground, and if the judge decides to refuse permission, then the duty of the judge is to give reasons as to why permission is refused on that particular ground. So
you could have a case, a very crude case, but just a useful example to play with, where the grounds of appeal run over 2 pages.
Yeah.
Grounds 1 to 3 are on the first page, grounds 4 and 5 are on the second page, and it is established that due to some administrative error at the part of the court, they only had the first page, and therefore they only dealt with grounds 1 to 3. You would say, obviously, I think 4 to 5. There's been a breach of natural justice because only 3 of the 5 grounds have been considered.
I will, of course, make that submission, but I will also accept that well, that does not necessarily mean that judicial review succeeds. It would be open to the Judicial Review Court after considering whether there is jurisdiction to look at those grounds to see whether the grounds are hopeless or whether they
Right,
can
so,
possibly
but I just want, that's interesting. Analytically, though, that comes in at the point that it has jurisdiction, because there has been an error,
Yeah.
but it doesn't follow that it has to exercise that jurisdiction in
Yes.
favour of granting
Yes.
permission
Yes.
or A40, or indeed if it does grant permission, but when it has a full hearing, it's satisfied there's nothing, it doesn't have to grant judicial review.
Yes.
But at one or other stage, it can fail.
Yes. So it is, the submission is that it is the second stage where, in my respective submission, the Judicial Review Court would consider the significance of the relevant grounds that have not been considered. You then have paragraph 33 of Ms. Justice Saini's judgment. Now, this is the paragraph that Miller and Friend cites in her skeleton argument. And you'll see that Ms. Justice Saini there has placed a gloss, in my respective submission, on the statutory language.
So which paragraph are we on?
It's paragraph 33.
Yeah.
The third sentence, which is on the next page, page 158, without seeking to be prescriptive, in my judgment, that, this is the test, requires a claimant to identify a failure in process which is so grave as to rob the process of any legitimacy. Now, this, in my respective submission, is a gloss on the statutory language. Now, this court considered this judgment in LA and did not endorse this formulation. And I would respectfully invite the court not to endorse this formulation in this appeal. The test isn't whether there is a failure that is so grave as to rob the process of any legitimacy. The test is one that is set out clearly in my respective submission in section 11A, subsection 4.
What do you say about the concluding sentences of that paragraph?
Well, there's no issue with that, yes.
Right.
What fairness demands has to be assessed holistically. I think this is the point that my Lord Vice President picked upon in LA, that in deciding whether there is a procedural defect in the Upper Tribunal's decision, it is in principle open to see what has happened in the first-year tribunal.
Well, I find that very difficult. I don't think that's really what the words say. It just seemed a very surprising result, but we left it open.
Yes.
So I wouldn't put too much weight on that.
Yeah. So I have no issue with the proposition or conclusion that fairness has to be assessed holistically. I have no difficulty with that. But I do respectfully submit that the gloss that is placed by Mr. Justice Saini is not one that the court should endorse.
No, but there's more than one point being made in 33.
Yeah.
I take your point about the parsing of what fundamental means.
Yes.
But there's a separate point, which is that you don't just look at the individual blemish that is being identified, but you look at the blemish in the context of the issue in the case as a whole.
No, I entirely accept that. My only objection to this particular paragraph is the third sentence.
Third sentence.
Yes. Now, this court considered the obligations of the Upper Tribunal in considering whether to grant or refuse permission to appeal in Wasif. That authority is behind tab 14 of the bundle. and my Lord, the Vice President may recall that this was a case about the totally without merit certifications. And can I just take you straight to the paragraph that is relevant for the present purpose? That paragraph is paragraph 19, which is at page 329. You'll see that my Lord there stated that where a judge refuses permission to apply for judicial review on paper, and that also applies in my submission to permission to appeal, he or she must, of course, give reasons. So must is the word that my Lord used. There is a duty to give reasons. And my Lord then made a point that that it was considered to be sufficient to provide reasons in summary, in an extremely summary form. You'll see a reference to plenary, and why it is important to give reasons for a decision. So you do not, this is paragraph 20, the reasons need not to be lengthy, but all of the claimant's points must be identified and addressed. If they are professionally pleaded grounds, those grounds should be taken in turn. You must engage, you must decide whether the grounds that are before the upper tribunal are arguable, and you must give reasons for the decision.
Mr. Mayor, you make a lot of this in your skeleton argument, and I obviously see why, but in a sense, isn't this a secondary point? The fundamental point is simply these grounds were not considered at all.
Yes.
It's not that these grounds were rejected without reasons. Insofar as you have a point, it seems to be accepted that the judge just didn't see the supplementary grounds. So reasons is a bit of a red herring, isn't it? Or it's your case is a fortiori.
Yes. I mean, of course, this is an additional point that I make, and the point is of some relevance in this case in understanding why there is an obligation to actually expressly decide each of the grounds that is put forward. The obligation is to engage with those grounds and to give reasons.
Yeah.
Now you have the judgment in plenary, and you're familiar, of course, with.
Do we really? I mean, of course, if you want to take us to it, do. But it's a ringing endorsement of why reasons are a good thing, which I think we.
Yes.
Okay. And if there is a passage, take us to it.
Yes, I will, because the judgment actually links the duty to give reasons with fairness and due process. So if you look at page 381 of the report, the very first sentence makes it absolutely clear that there is a general duty to give reasons. And just at the end of paragraph 381, between letters G and H, you'll see general comments as to the duty to give reasons, and you'll see that that is linked to function of due process and therefore to justice. Fairness requires that the parties essentially, the losing party should be left in no doubt why they have won or lost. So the duty to give reasons is, in my respectful submission, is an aspect of fairness and natural justice. And these are reasons as to why that is so. Now, there is one further reason as to why there is, in this particular context, an obligation on the judges to expressly consider every point that is put forward by an applicant, as long as that point might tell something in favor of that applicant. And that is the principle of anxious scrutiny that applies only that applies in this context. The authority for that proposition is Y Hatch. You have that authority behind tab 15 of the authorities bundle. And the relevant paragraph is paragraph 24. This is page 350 of the judgment. Page 350 of the bundle. And you'll see that that paragraph tells us what the anxious scrutiny requirement actually entails. Just against letter D, you'll see that the decisions, these are the decisions made by the Secretary of State, made by the tribunals, need to show by their reasoning that every factor which might tell in favor of an applicant has been properly taken into account.
So did you say paragraph 24?
Paragraph 24, yes. Just again,
Yes, I see.
letter D.
Yeah. Okay.
Every factor which might tell in favor of an applicant has been properly taken into account. And this is the approach that the Upper Tribunal applies when considering an appeal from the first-tier tribunal, or the Judicial Review Court would apply when considering a challenge to the Upper Tribunal's decision. If the decisions do not show that every factor which might tell in favor of an applicant has been properly taken into account, then there would be a failure to comply with anxious scrutiny, and that is a ground of appeal or a ground of judicial review. So what one gets in my respectful submission from this analysis is that the exception in section 11 for Roman 3 would apply if there is an arguable failure by the Upper Tribunal to put forward the grounds of appeal in support of an application, or if there is an arguable failure to give reasons as to why those grounds are unarguable. Now, my lords.
So it would apply if there's an arguable failure to do what? To
An arguable failure to consider
yeah.
the grounds of appeal
Yeah.
put forward by an applicant.
Yeah.
And secondly, if there is an arguable failure to give reasons as to why
okay.
those grounds are unarguable.
Okay.
Now that is what happened in the present case. Full factual background is set out in skeleton arguments. You'll see that following the decision by the first-tier tribunal refusing permission to appeal to itself, or permission to appeal to the Upper Tribunal, the appellant filed an application for permission to appeal with the Upper Tribunal. That permission application, if you wish to see...
Would you mind, at this stage, I would certainly be helped if we just traced through the grounds
Yes.
that were asked of the first-tier tribunal and refused, then the grounds initially to the Upper Tribunal, and then your ground.
Yes.
Good.
So may I take you first to page 160 of the bundle. This is the core bundle. These are the grounds submitted to the first-tier tribunal for permission to appeal to the Upper Tribunal.
Remind me the date.
8th of April 2022. You'll see that this is a detailed document that sets out the full factual background of the case. You'll see that two grounds are pleaded. Ground 1 is at page 162, and that concerns paragraph 276 ADE of the immigration rules.
Yes.
And the second ground concerned Article 8, which is at page 167. And the point that is made in that ground is that the appellant was providing a service to the community, and the judge's approach to that matter was flawed.
So the judge didn't give weight to the fact that the applicant was saving public money.
Yes. The first year tribunal refused permission to appeal. That refusal is at page 159 of the bundle. And you'll see
Date of that, I'm sorry, I've got this somewhere. But
sorry, this is 16th of May 2022.
and where did you say that was? That's
This is page 159 of the bundle.
yeah.
You'll see that said essentially that the grounds were not arguable. I'm not sure with respect whether the grounds were accurately summarized and dealt with, but that's not a matter.
Water under the bridge. Yeah.
Now, the application for permission to appeal to the Upper Tribunal is made, and you have those grounds starting at page 146. The date on which the grounds were settled is 15th of June 2022.
Just remind me, is that in time?
That is in time indeed, yes.
So this is still Mr. Saini.
Yes.
Is it identical? In a sense, it's a
It is
matter of history. It is identical to the previous grounds, is it?
Yes.
Yes.
Yes. Now, just for the purpose of note taking and the question that my lord asked, so the decision of the first year tribunal that I showed you is dated 16th of May 2022.
Yes.
But that decision was served or sent to the parties on 7th of June 2022. The appellant had 14 days from that decision, from that date, to make an application for permission to appeal to the Upper Tribunal. And permission to appeal to the Upper Tribunal was made on 18th of June 2022. So it was an in-time application. You then have the supplementary grounds of appeal, dated 4th of November 2022. And those grounds are at pages 142 to 145 of the bundle. And you'll see the additional ground at paragraph 3, page 143, which concerns the first year tribunal's conclusion that there was no protected family life between the appellant and Dr. Allen. And the submission is that finding was legally flawed and inadequately reasoned.
So the focus of this we might describe as your ground.
Yes.
Was the difference between private life and family life.
Yes, and the finding that family life limb is not engaged.
Yes, but the substance of it was that there was some difference between a very close private life.
Yes, there is. Yes.
And family life.
Yes. Yes. I'll address you further on this, but perhaps just to give you a sort of headline point. I mean, if family life limb is engaged, then the case law tells us that the task of the tribunal is to look at the family life right of every person that is involved. So the tribunal would not simply be focusing on the right of the appellant, but also the right of Dr. Allen.
Yes, I see.
So that's Bianco.
That's Bianco, yes.
Sorry, the word.
Beato Betts,
Yes,
it's
Betts,
a Supreme Court or House of Lords
Thank you.
decision, I can't remember which, says what
Yeah.
you say it says.
Yes, yes. Whereas if the appeal proceeds only on the basis that private life limb is engaged, then the decision maker will simply focus on the private life right of the appellant as opposed to the right of the other family member. So these are the grounds. Now it's common ground that these grounds were sent to the Upper Tribunal. They were sent to the Upper.
The 4th of November.
Yes. Now these grounds were sent to the Upper Tribunal. If you wish to see the communication that was sent to the Upper Tribunal, it is in the supplementary bundle at page 8. You'll see that the grounds were sent with a cover letter. And a request was made to place the supplementary grounds before the judge who was dealing with the matter. You'll see the solicitors also asked for an acknowledgement.
I mean, this was, what, 4.5 months,
Yes.
say 4 months, after the time limit for filing grounds of appeal.
So this is the respondent's notice point 1.
Yes, but I'm just following this through. That
Yes.
It turned out that the decision was taken 10 days after this.
Yes.
But you weren't to know when the decision was going to be taken.
No.
But I mean, look at it in the round. The decision might have been taken
Yes.
2 months before then,
Yes.
or it might have been taken 2 months after.
Yes.
It was out of your hands, and
Absolutely.
it wasn't one of those cases where there was a hearing date, for example.
No. Absolutely. But the fact of the law is that the decision wasn't taken by that date. The grounds were settled with a request to place those grounds before the tribunal. There was also a request to acknowledge the grounds. Now, the grounds were acknowledged by the Upper Tribunal, and you'll see the acknowledgement on the next page, paragraph 10. This is where perhaps it may assist in relation to the question that Lord just asked. The Upper Tribunal confirmed that the application was still under consideration. That is 9th of November 2022.
Yes, so I'm not making any point in favour of one or other side, but it is the fact anyone receiving that and having said please place it before the judge, and they
Yes.
say it's still under consideration, you would assume that means it will be put before the judge.
Yes, but we know for a fact that the grounds were not put before the judge. Now you then have the Upper Tribunal's decision refusing permission to appeal to itself.
Yes, that's the one which you've got, and there's a better copy of.
That's the better copy, yes. In the bundle, it is at page 139. The electronic copy is a little better. But anyway, you'll see that...
Page, sorry, which page?
It's page 139.
Yes, thank you. Yeah.
Now, if you look at paragraph 2, you'll see that the judge identified 2 grounds and then explained why those grounds were not arguable. There's absolutely no doubt that the supplementary grounds were not considered by the judge, and no reasons are given by the Upper Tribunal as to why the supplementary grounds are unarguable.
Did anybody then get in touch with the Upper Tribunal and say?
No. And there is a reason for that, and that again is respondent's notice point number
Well,
one.
I'm not trying to pigeonhole it, but in a sense, the obvious thing to do at this point is to say you don't appear to have
Yes.
taken account of my ground.
No, the difficulty with that, and I promise I'll address you properly on this. The difficulty with that is that the case law demonstrated very clearly at the time that once permission is refused by the Upper Tribunal, then Upper Tribunal has no power to do anything whatsoever. It has no power to review the refusal of permission to appeal, even if it is convinced that that decision is wrong.
Okay, well,
wasn't-
you'll come back to that properly. But anyway,
Yes.
the fact is, nobody did get in touch with the Upper Tribunal and say what's happened, but you say that's justifiable for the reason you've trailed. Yep.
So that is the Upper Tribunal's decision. You then have the decision made by the High Court on at the renewal hearing. You have the judgment at.
Well, on the 6th of December, you made the JR application. So, for the reasons that you've explained, permission having been refused on the 16th of November, on the 6th of November, you applied for JR. Is according to my note. I've got it from somewhere.
Yes. That must be right. Yes.
Right, I'm sorry. You were then taking us to.
Yeah, so it's 6th of December when the judicial review claim, it seems, was filed. Now, the judgment that is the subject of this appeal starts at page 67. May I take you to page 71 of the bundle, paragraph 24 onwards. This is where the actual analysis start.
This is an extemporary judgment
Yes.
given on the day.
Yes. So paragraph 24, the judge said that the failure to consider the supplemental grounds might just conceivably be framed as depriving the claimant of her right to be heard, and that it is potentially at least arguable that this would stretch so far as to be a fundamental breach of natural justice. So yes, right to be heard. The additional reasons, no reasons were given. But the judge then says that I do not decide that.
You could read that as him saying,
yes,
it's disputable.
but I'm not deciding that. Yes.
It's disputable, but it's disputable, but I won't decide it. Or he could be saying it could be disputable, but I'm not deciding whether it's disputable.
Yes. Well,
I think it's the latter actually, but
in my submission, he is saying that it is at least potentially arguable. It is disputable, but the judge would not decide whether the point is a
yes,
good
I
one.
see. Yeah.
For the reasons given.
But that was a point, in a sense, in your favour.
Yes, it is. Yes, and yes. So the assumption that judge made in my respective submission was the correct assumption. Now, if you then look at paragraph 26, this is what the judge says that the judge gave reasons for refusing permission. The judge assumes in the appellant's favour, but then refused permission, essentially applying the second-tier appeals test. Now that, with respect, is just indefensible. It is plainly wrong.
Well, you wouldn't have a problem, if I've understood your submission so far, if he'd applied the first appeals test. If he'd applied, the ordinary JR test, i.e., is there an arguable point?
Yes.
What you're saying he was wrong to do was to add the carte extra.
Yes.
Yeah.
And you then
Can we just pick out why that is so? Have I got this conceptually right in my head? If, as the judge either decided or assumed, there was a disputable point here, so the jurisdictional bar is lifted, that may not be quite the right way of putting it, but section 11.2 is disapplied.
Yes.
Because 11.4 starts by saying section 11.2 won't apply if. So that raises, just so I can get this clear in my head, 11.2 is disapplied, which means you go back to what the position would be apart from 11.2.
Yes.
Where do we find that?
Well, I think in LA, in the paragraph that I showed you.
Well, LA's a case. I just want to know statutorily, where do we go back from that? If 11A2 doesn't apply,
yes,
that means that it is reviewable, that a decision to refuse permission to appeal is, so permission to apply for judicial review, is reviewable, square brackets, on ordinary principles.
Yeah.
I just want to know what the ordinary principles are under the statute. If you go back to section 11, which is the one which actually gives jurisdiction to the Upper Tribunal to hear appeals from the FTT, it simply says there is a right on a point of law and it is with permission. But it doesn't specify the test for permission.
No.
So I don't quite know where the test for permission is or is specified for a case where 11.2 doesn't apply. It's there somewhere, I'm sure, but I would just like to track it down.
Yes, it's not in the primary legislation.
No.
It is in the practice direction that the senior president has issued, which is essentially to the effect that if the appeal has a real prospect of success, or if there is some other compelling reason why permission should be granted.
So there is, in fact, certainly no statutory, but not even in secondary legislation. Do practice directions in the Upper Tribunal have the status of? Are they the same as practice directions in the CPR? I don't know. Are they?
No.
They're not legislation.
They're not legislation. Yes.
None of this, Matt, I just want to get it right.
Yes.
But you say, I'm sure it's common ground, but the basis of it is, it may not be common ground.
Yeah.
If 11.2 is disapplied,
yes,
you say the test for permission is simply arguability.
Absolutely.
Or some other compelling reason.
Yes.
Yeah.
I was just rereading 26. You took us through it.
In LA.
No, 26 in
the judgment.
In the judgment. I'm sorry. I'll just pause for a moment. So.
Yes.
I was wondering about your point that the judge was applying the second appeals test.
Yeah.
You forgive my relative ignorance of this, but I think you've just taken us to the fact that a judge who is considering whether to grant permission for judicial review will consider whether there's an arguable case with a reasonable prospect of success.
Yes.
And that's one gateway to judicial review.
Yes.
And that there's a second gateway,
Yes.
which is to do with the important point of principle or practice, or some compelling reason for judicial review to be offered. Is that correct or not?
No. So far as the second-tier appeals test is concerned, it has two limbs.
No, I'm not talking about the second appeals test. I'm talking about the basis upon which you can grant permission for judicial review.
Or arguability, or some other compelling reason why permission should be given.
Yes, so the concept of important point of principle or practice doesn't feature in the ordinary test. That was imported by Cart by analogy with the second appeals test.
Yes.
So it's the fact it has to tick
One.
that gateway as well
For a second appeal.
for a second appeal, but also until the change in until the introduction of the provisions we're looking at.
Yes.
Also for PTA JR of an Upper Tribunal refusal of permission,
Yes.
because that's what the Supreme Court decided in Cart.
Yes.
Just making it up out of their heads by analogy.
Yes.
Yeah.
But I'm not sure that the judge at paragraph 26 is in fact applying a second appeals test.
No.
Because I think that that there is some difficulty maybe with the transcription, or if you see after the semicolon at the end,
Yes.
he says, and that either.
Yeah.
Now, that could be an error for or, that either the claim raises an important point of principle of practice, and then there's another mistake,
Of that.
potential mistake here. Practice of clearly means or, that there is some other compelling reason to hear it.
Yes.
So I just wanted, in fairness to the judge, consider
Yes.
whether he could possibly have been considering that he was applying a second appeals test, rather than, as I understand it for JR, the applicant has two targets to get permission. You either have
Yes.
merits, or you have a really big point.
Yes. So yes, I see. Now, in my submission, the judge was applying the second-tier appeals test at paragraph 26. The language that the judge has used is taken from CPR 54.7a. This was the provision in the CPR that dealt with court judicial reviews, which is now changed. And this is how the second-tier appeals test was set out in that paragraph, in that rule at the time. And it essentially had sort of three limbs. Limb one, a reasonable prospect of success, a reasonable prospect that both decisions are wrong. Second, some other, an important point of principle of practice, or some...
It had two limbs, one of which was subdivided.
Yeah.
The first limb was the classic first appeal,
Yes,
or first, which is merits or a big point.
yes,
Well, no, merits or some other compelling reason.
yes,
And then it had a separate second limb, which is important point of principle or practice.
yes,
You could say probably if there was an important point of principle or practice, that would actually
yes.
also be some other compelling reason. But conceptually, they're separate.
Yes. Yes.
But you may or may not be right about what you may be right. The judge was, even if inaccurately transcribed,
yes,
attempting to quote 54.7a, in which
Yes.
case he was applying the CART test. But if you actually look at his reasoning below,
Nothing so.
he doesn't put you down on the CART extra. He doesn't say, okay, you have got an arguable point, but it's not important point of principle or practice. He just says you haven't got an arguable point. So ultimately, though it may be of interest for other cases,
yes.
it doesn't really matter, does it here?
Well, in my submission, it does. If you look at paragraph 29, and I will, if you look at paragraph 29, this is where the judge, after discussing the case law, says this. It seems to me that the judge's finding about the absence of family life was justified. Now, that, with respect, is not a question to be considered at the judicial review stage.
I fully follow that point.
Yes.
You have a number of arrows in your quiver, but I'm
Yes.
at the moment examining your argument that the judge wrongly applied
The second year.
the second appeals test. And at the moment, I was just flagging up that I'm speaking for myself, unpersuaded by that, because he simply deals with arguability, and he doesn't even refer to that. I mean, he would surely, if he was considering that he was applying, as it were, you had to hit both targets. He would have said, and if I'm wrong about that, then this isn't an important point. He doesn't do that.
No.
He appears to be treating it for all the world as if it's an arguability issue.
Yes.
That was all.
I accept that. Yes. Yes.
Okay, that's helpful. Could you just, with perhaps Mr. West's help or Ms. Thalen's, give us the reference for the practice direction that spells out what the
Yes.
ordinary test for PTA-JR is from the
Permission to appeal.
permission to appeal is in the Upper Tribunal.
Yes. Yes.
In a way, it's odd because the CPR does say the rule in the for appeals in the ordinary courts, but there's no equivalent to the Upper Tribunal rules.
No.
I had a look and couldn't find it, so that's. I'm sure you're right. That's
So
puzzled.
we'll provide you a copy of the relevant practice directive.
Thank you very much.
Yes. So paragraph 29, the judge says that the finding is justified. That isn't the question to be considered at the permission stage. The question is whether it is arguable that the findings are justified. And even if the findings are unarguably justified, if the reasons aren't adequate, or if not every factor which might tell in favor of an applicant has not properly been taken into account, the anxious scrutiny principle, the upper tribunal will nevertheless grant permission to look at the matter substantively.
Doesn't 29 have to be read along with 26, where he says in the second line, I'm not persuaded there's an arguable case?
Mm-hmm. And 32,
Yes,
about it.
and
The reasoning was not arguably wrong in law.
Yes. So what he says at paragraph 29 is, in my respectful submission, wrong in law. But what he says about at paragraphs 30 and 32 is just wrong. This is a case where it was at least arguable that the judge's decision was wrong in law. But I do respectfully emphasize again that the task of the judicial review judge is not to consider whether the appellant has a real prospect of success from the first year tribunal to the upper tribunal. The task of the judge is to decide whether it is arguable.
Yeah.
It is arguable that there is a real prospect of success, or it's arguable that there is a compelling reason. So
I mean,
the judge,
in many ways, what's happening here is Justice Griffiths in this decision is sort of doing a reconsideration of Judge Grubb's.
yes,
I appreciate you say he shouldn't have been,
yes,
but actually, if one's considering the overall fairness of the situation, your client's complaint was she didn't get a chance of a second appeal.
yes,
Of an appeal from the refusal of her appeal. She didn't get into the upper tribunal,
yes,
but in a sense, she got into the High Court
yes,
on exactly the sort of issues that the upper tribunal would have been considering had it had all the material. And not only that, but she also got an oral hearing.
yes. But the submission I do with respect make is that wasn't a proper question to consider at the commission.
But I understand this, but it's sort of with this. I mean, even today, for example,
Yeah.
I mean, permission. You haven't got permission for this appeal.
Yeah.
So I mean, the whole thing is like a gigantic onion. I mean, we're just peeling away layer after layer
Yes.
of this. But I mean, every so often, has to step back when
Yes.
when looking at the reality of the issues that are being faced. So I appreciate that you have points to make about whether he should have been considering this or should have been considering that. But in substance, wasn't this very much like an oral application for permission to appeal to the upper tribunal?
But if a judge takes the view that the grounds of appeal from the first year tribunal to the upper tribunal are hopeless, a judge can properly refuse permission. I have no difficulty with that. But in the circumstances where the grounds were not considered by the upper tribunal at all, in my submission, it wasn't proper for the judge to consider at a permission hearing that ought to focus on the question of jurisdiction and exception, the substantive question that the upper tribunal would consider. That is a question for a full substantive hearing, for a full argument, or for the upper tribunal. Now, if I may now just turn to the points made in the respondent's notice.
Yeah.
Because sorry, just to interrupt, Mr. Malik, because if the JR succeeded,
Yes.
the application for permission to appeal will be remitted to the upper tribunal for it
And
to
the upper
consider
tribunal will
it.
decide, yes. And the upper tribunal will decide whether to grant permission or
Yes,
refuse permission.
exactly. Yeah.
Presumably you have that slight anomaly. I don't know whether there's a procedural way around it that we have with appeals to us from the upper tribunal.
Yes.
That
Yes.
if the Upper Tribunal judge if the judge on the JR says it is arguable
Yes.
that it was arguable,
Yes.
it's a waste of time to go to a
Yes.
full JR.
Of course.
And the parties then, if they're sensible,
Yes.
settle
Yes.
and go and agree to an order sending it back.
Yes.
Funnily enough, we had just such a case yesterday.
Yes.
Well, you were going to be in it,
Of
weren't you?
course I was. Yes.
Yes, the Secretary of State took a long time to
Yeah.
realise that was the position. But that's a position you can also get, or in theory, presumably,
Yeah.
in these JRs of refusals to permit.
Yes, and that is actually provided for in the CPR. So in CPR 54.7a, provided that where the High Court grants permission to apply for judicial review
Yes,
in a card case,
yes.
then it will then proceed to quash the decision without a hearing,
I see.
unless someone makes an objection.
I see. So someone had spotted that point and had
Yes.
provided for it in CPR 50, which is now gone, of course. So,
Which is now gone.
but,
Yes.
but under the card. How interesting. Okay.
Yes, that perhaps would be a classic case where the Upper Tribunal says there is no error of law, and the High Court, there is no arguable error of law.
Yeah.
The High Court disagrees, says that there is an arguable error of law, or it's arguable that there is an arguable error of law. There's no point having a substantive hearing.
Yeah.
And the parties can agree for the decision to be quashed. But
Yeah,
this is a
okay.
case where the Upper Tribunal has not considered.
Okay. Well, okay. That's
the law.
that's very interesting. But as you say, we're not in that position
No.
here.
And if you grant permission, if the appeal succeeds, then the default position would be that there would be a remittal for a substantive judicial review hearing
Yeah.
at the High Court.
Yeah. Okay.
But in practice, it
What's
may
the
be
point?
that
Exactly. In practice, there's no point.
There's
So the
no
rule
point.
actually allowed for it to go back
to the Upper Tribunal.
to the upper, and even if there wasn't a rule,
That the
there would
parties
be
agreed on.
the parties could do it by agreement, and always would. Yeah.
Yes.
Okay.
So now the respondent's notice, the 2 points that the Secretary of State makes. The first is that the appellant could have applied to the Upper Tribunal.
Mr. Malik, I'm extremely sorry, and to my colleagues, but can you just remind me, what are you asking us to do if we're in your favour in this appeal?
Well, allow the appeal and set aside the order of the High Court, grant permission to apply for judicial review, and remit the
But
substantive hearing.
aren't we in the same world there? I mean, are our powers limited to doing that? Why would one not find some way of sending it to the Upper Tribunal?
Well, no, we'd send it back. Surely, yes, we'd send it to the Upper Tribunal. Well,
Yes.
if you knowing you, Mr. Malik, you may have this at your fingertips, but if you don't, just let us. There will either be a rule that allows us to do that,
Yes. Yes.
or
Yes.
you will simply rely on everyone's common sense
Yes.
to apply the usual practice where there isn't a rule.
Yes.
If I got that right.
Yes. Yes.
But formally,
Yes.
you will be asking us to, at least as a first step, to quash the decision of Judge Griffiths
Yes.
and grant permission to apply for judicial review. But the next step is nobody actually wants that, and by one route or another, which you will point out to us, it will then go back to the Upper Tribunal for a proper appeal.
Yes, I have no difficulty with that. The reason why I suggested that there be an additional step, because my learned friend may advocate for it, because when you're deciding whether to grant permission to apply for judicial review, you're deciding whether it is arguable that there is a real prospect of success. But the test for granting...
The two are the same, aren't they? In all practice.
Yes.
Yes. I mean,
There aren't two levels of arguability. That's why the whole thing's a nonsense.
Yes. But there is, yeah.
Anyway, look, we'll hear from Miss Taylor, Thalen about this when she gets to her feet.
I note that the latest refusal of your client's claims celebrated its 5th birthday this week.
Yes. It's taken
I mean,
quite a lot.
it's just sort of absurd.
Yes. Subject to any suggestions, I have no difficulty.
Okay, you want to jump to the respondent's notice points?
Yes. So two points are made in the respondent's notice. The first point has sort of two limbs. Limb one is that the appellant could have applied to the UT to reopen permission to appeal. And the second limb is that the supplementary grounds were out of time.
Yeah.
And that means, looking at the process as a whole, there was no procedural defect. That's the first respondent's notice point. The second point is that the High Court was right to hold that there was no error of law in the first-year tribunal's decision. So may I just address you on the two or 3 points in turn?
Yeah.
So first, that there was no application by the appellant to apply to the Upper Tribunal to reopen the proceedings. Now, that was just not possible as a matter of law. The Supreme Court made it absolutely clear in court, and in fact, that was one of the fundamental reasons why the Supreme Court introduced the second-year appeals test. CART is behind tab 4 of the authorities bundle. And the paragraph that is relevant is paragraph 28. You have that paragraph at page 70 of the bundle. The first-year tribunal and the Upper Tribunal have powers to review their own decisions, but the power does not apply to an excluded decision. Now, refusal of permission to appeal is defined in the statute as an excluded decision. This means that the Upper Tribunal has no power to review its own decision to refuse permission to appeal to the Upper Tribunal, even if it is convinced that the decision was wrong. And that was one of the reasons why the Supreme Court said that one cannot really exclude judicial review altogether. There has to be some way to get to the High Court. So that was the position then, and that was a sort of settled position that it wasn't an option for the appellant to apply to the Upper Tribunal to...
And so there were no provisions, as one sometimes finds in various sets of rules, for reopening in case of administrative error or anything.
There is a provision.
But it doesn't apply to an exclusion.
It doesn't apply to refusal of permission to appeal, according to CART, this particular paragraph, because the power to review and set aside a decision is limited to decisions that are not excluded decisions. And refusal of permission to appeal is defined in the statute in section 13 of the 2007 Act as an excluded decision. Now that particular provision was considered by this court in an authority that you have behind tab 9 of the bundle. Now this authority wasn't available when the Upper Tribunal refused permission. It's a 2023 judgment, came out on 18th of July 2023, but it does not assist in my respectful submission. It does not assist the Secretary of State. If you look at page 164, the parties were not represented in that case. But what is remarkable, looking at page 164, is that CART was not even placed before the court. You have the list of the relevant authorities at page 164. Now the question...
Yes, I'm not making a point about this, but I noticed that judgment was handed down really the day after the hearing, or 2 days after the hearing.
Yes. Now, paragraph 1, that the issue before the court was where the Upper Tribunal refuses to set aside a decision on Rule 43, whether there is a right of appeal to this court. And the court decided that there was. But the paragraph that causes some difficulty with respect is paragraph 15, which is at 169. which appears, say this with the greatest of respect, which appears to be irreconcilable with CART. It wasn't an issue in that case, but Lord Justice Lewis said that the Upper Tribunal may, under Rule 43, set aside a decision which disposes of proceedings and remake the decision. And that, he says, applies to decisions refusing permission to appeal as well.
But you say that, if this is part of the ratio,
Yes.
then we're bound by it unless it's per incuriam. But in fact, you're saying it's not part of the ratio.
It's not part of the ratio. And if the Secretary of State is seriously asking the court to endorse this approach, I, in principle, have no difficulty with that. But that would make a nonsense of Section 11 mechanism altogether. So think of a scenario where an applicant is refused permission to appeal by the Upper Tribunal. The whole purpose of Section 11A is to limit the ability of an applicant to challenge that decision. Now, that applicant will simply put in an application to the Upper Tribunal to review its own decision. And if that application is refused, that applicant would sidestep Section 11 altogether and would bring an appeal to this court.
Well, perhaps, I mean, you're taking it very succinctly, which is good, but can we just see what the provisions are?
Yes.
Section, we've got, not sure we've got them all in our bundle, but they're in.
We do have Section.
As we've got Plescan open, let's just look. Section 11 is set out at 7.
No.
Sorry, it's paragraph 7 of his judgment.
Yes. Yes. So it's paragraph 13 of the judgment where you have Rule 43.
Yes, but I'm just telling. But that's where Section 11 is. So that gives the basic right of appeal.
Yes. Yes.
And then Section 13 is the right of appeal to this court.
Yes.
Yeah. Okay. Now, then Section 10 is the power to review.
Yes.
But it excludes, but doesn't apply in case of excluded decisions.
Yes.
For the purpose of Section 1. For the purpose of Section 13.1, and if we look to Section 13.1, where would we find the definition of excluded decisions?
13.8.
Section 13, subsection
8.
And it's...
so the first one, any decision of the Upper Tribunal. Yep.
Yeah.
Right, now, sorry, I was taking you more slowly than you wanted to go. And then 43...
Yes. So this is where the Secretary of State says that where the Upper Tribunal refuses permission to appeal, an applicant can apply under Rule 43 for the decision to be reviewed, where certain requirements are met, and those requirements are far, far more generous than Section 11 test. So where a document was not sent or received, where a party was not present, there was other procedural irregularity, you can apply to the Upper Tribunal to review the decision.
So how does this work? That this all applies to cases where the Upper Tribunal has given permission, but not to cases where it's refused it? Is that?
Yes, so refusal of permission is an excluded decision, but there are a number of other decisions that the Upper Tribunal may make that are not excluded decisions. For example, a substantive decision dismissing or allowing an appeal, that is not an excluded decision. It can be reviewed under Rule 43. Refusal to adjourn the hearing can be reviewed.
But your permission is that Rule 43 can't apply to excluded decisions. Now, it doesn't say so in its own terms,
No.
but you're saying that it would be inconsistent with the primary statute, Section 10.1. Is that the point? Is that why should we read a limitation into Rule 43 that isn't there?
Yes, no, it's in Section 10, and this is what the Supreme Court picked in court. Section 10.1 says
yes, I see,
that the Upper Tribunal may review a decision other than an excluded decision. And excluded decision is defined in Section 13.8 as including refusal of permission to appeal.
this may be right. I'm not doubting what you say at this point, but it would seem a bit odd that, for example, a mislaid document
Yes.
can be reviewed in a case where permission has been granted, but not in a case where permission has been refused.
Well, it's the actual decision refusing permission that is an excluded decision.
Yes, but that's. I mean, I'm just pointing out that it seems a bit. It
Yes.
seems a bit counterintuitive that.
Yes, I see the point, and I've taken.
Would you just say that's what it says?
Yes, and that's what the Supreme Court has said in court. Now, for my part, I have no difficulty if this court were to say that refusal of an applicant can apply to the upper tribunal, where permission is refused.
But all you need to establish for our purposes is that it shouldn't be held against you that you didn't.
Precisely, yes. But if this court is to accept the Secretary of State's invitation, I've no problem with that. But that will cause some serious issues as to Section 11A. I mean, what is the point of introducing the Section 11A test if a person can simply sidestep that test and ask the upper tribunal to review its decision on much generous grounds, and if the upper tribunal refuses to do so, you appeal on the first appeals test to this court. That makes, in my respective submission, little sense. But that's not the point that
you basically say one Plescan doesn't say what it appears to say, or it's not authority for what it says, because with respect it's wrong, and we can see why, because it wasn't fully argued and so forth. And anyway, it's obiter. But if you're wrong about that, you say it can't be held against you.
Yes.
That you didn't take this route, since until Plescan there was what appeared to be a clear statement of law in the Supreme Court level that you couldn't review it.
Yes.
Yeah.
If the court is persuaded by the second point that this shouldn't be held against me, then there is no need for the court to decide whether.
But that's why you say it's no. You don't mind what the answer to the first point is. It's because you would then rely on the second. Is that right?
That's absolutely right. And the reason perhaps why it wouldn't be appropriate for the court to decide the issue of law one way or another is because it makes no difference to me, and you don't have
also
sort of benefit.
Essentially, it would be likely to be obiter
Yeah,
in the present case.
yeah. Well,
Possibly.
let us suppose that we are persuaded, having heard Miss Thalen, that there is a problem with paragraph 15 of Plescan.
Yes.
We will have to decide whether the best thing is just to flag it up, whether to say nothing at all,
Yes.
or to flag it up and leave it for another court, or actually to say what we think about it,
Yes.
but in circumstances where it might be obiter,
Yes.
depending on the structure of our reasoning.
Yeah. I mean.
Okay, well, we
colleagues-
have your position on this.
I'm very grateful.
Yeah.
Very grateful. Thank you. So that's the answer to the first limb of point 1 in the respondent's notice. Second limb is that my supplementary grounds were out of time. Now, I, with respect, do not accept that the supplementary grounds were out of time. But even if I'm wrong about it, it makes no difference. Now, a person, I'll explain why I say that the supplementary grounds are not out of time. Now, a person has 14 days from the date of the first year tribunal's decision refusing permission to appeal to make an application for permission to the upper tribunal. Now, this is Rule 21 2AA of the Upper Tribunal Procedure Rules. You have those rules in the bundle if you wish to see them, but you have 14 days to bring an appeal. Now, here the first year tribunal's decision was made on 7th of June 2022, and within 14 days, the notice of appeal was filed. So the appeal was in time.
Presumably there's a
Now-
provision that the notice of appeal contains grounds.
Yes, so
Okay.
the notice of appeal, the appeal was in time. Now, the
I do
notice
think
of
we
appeal
need
is,
to have these in front of us. I appreciate that.
Do you wish to see,
You know them
see
very
the
well.
rules?
I think it's page 26, is it, of the authorities bundle?
Yes. Yes, page 20. Yeah, 26.
And you were referring, I think you said, whatever you said, it's 3AA, is it?
So it's 21 3 AA. Yes.
Thank you.
So the application must be made so that it's received within 14 days. Now the notice
And
of
just while we're there, perhaps you're about to go to it. 4B says it must include the grounds on which the appellant relies.
precisely, yes, yes, yeah. Now
So
4E.
4E.
yes.
Now the notice of appeal, my lady, my lords, is not served on the Secretary of State. It goes simply to the Upper Tribunal. If the Upper Tribunal grants permission to appeal, then the Upper Tribunal serves the notice of appeal on the respondent. That is Rule 22, 2B, which is on the next page, page 27, decision in relation to permission to appeal. So where permission is given, the Upper Tribunal will serve the decision and the notice of appeal on the respondent.
Does it follow there is no procedure, as there is in the Court of Appeal, for getting the respondent's observations on an application for permission?
Because the respondents, whether the appellant is the Secretary of State or the appellant, the notice of appeal is not served on the other side prior to the decision on permission to appeal.
So, for example, if you were a successful appellant in the FTT,
Yes.
a process might be going on in the office of the Upper Tribunal
Yes.
for months
Yes. And
without you being even aware that an application had been made to it.
so, at a practical level, the Upper Tribunal sends an acknowledgement to both sides saying that an appeal has been made, but would not serve the notice of appeal and would not
I
tell
see.
what
So
the
at least
grounds of appeal are.
you're told that something's going on.
Yes.
But that's by the UT, not by the
No.
litigant.
No. But by the Upper Tribunal, yes.
I see. So UT does say a notice of appeal has been lodged,
Yes.
but doesn't supply a copy.
No. So the acknowledgement is sent to the party that has filed the notice of appeal, and the copy is sent to the other side.
I see.
So the other side would know that there is an application permission to
Yeah, I
appeal,
see.
but the decision is not served. But the notice of appeal, the grounds are not served.
Yeah. Okay. Thank you.
Now, as a matter of law, in my submission, it is open to an appellant to add new grounds up until the point the Upper Tribunal makes a decision on permission to appeal and serves the notice of appeal on the respondent. So if an appellant files additional grounds and they are linked and placed before the judge along with the original grounds, the judge will consider the application, will look at both sets of grounds and make a decision accordingly.
But is that by way of an exercise of judicial discretion? A purist would say 21.4E requires you within 14 days to file an application stating the grounds.
Yeah.
If you want to rely on additional grounds, you will have to amend that document.
Now, there is an authority, my lord,
Ah.
precisely on that point. Now, and that is the judgment of this court, which concerns precisely the same point, but in the context of proceedings at the Upper Tribunal for judicial review. Now, a person applies for judicial review, sets out the grounds of judicial review in the claim form. And the question before this court was whether a party may amend the grounds
Yes.
without seeking the tribunal's permission prior to the decision being
Okay.
made.
Well, let's have a look at that.
And that is the judgment of this court in Sapayu, tab 12 of the bundle. So the issue before the court was when the Upper Tribunal's permission is needed to amend the grounds. The president of the Upper Tribunal said that you don't need the tribunal's permission up until the date of the decision or the date of issue. But this court said, well, you'll see the analysis of that question. If you go to page 296, you'll see a heading, when can an amendment be made to JR without permission? And for the reasons given at paragraphs 21 to 26,
Just help me, why is he looking at the civil procedure rules at all?
yes, because the Upper Tribunal procedure rules were silent, and what this court said was that, well, the approach in the civil CPR applies. The general approach in CPR is that a party may amend a document at any time without the court's permission prior to service. And this court said, this is paragraph 27, that this applies to the Upper Tribunal as well.
Is there anything in Part 54 about amending applications for judicial review?
Well, that is after the service.
That's after permission,
No, after service of the claim form on the respondent.
after service, right?
So if you once a claim form is served on the respondent,
Yeah.
you need the court's permission to amend the grounds.
I see.
But you can amend the grounds without court's permission before service.
Okay.
And this applies, the court said, to the Upper Tribunal too. Paragraph 27, Lord Justice Colson said that, well, that makes sense. If the respondent has not received the document, the respondent wouldn't know what is happening. But once papers are served, then the respondent would start preparing, and that would create confusion, etc.
Yeah.
And if you wish to see a succinct summary of the conclusion, it is paragraph 35.
35, you say?
Yes, 35. In judicial review proceedings, the statement of facts and grounds can be amended without permission prior to their service, but at any time thereafter, permission to amend is required.
Yeah. And you say, you acknowledge that this isn't actually about appeals, but
Yes.
you say it applies by analogy or parative reasoning.
Yes.
Could I just be clear as to what your contention is? You introduced this by saying that it was open to the appellant to add new grounds up to the time of the UT decision on permission to appeal. Do you mean by that it's open to add new grounds with permission, or it's open as of right?
It's open as of right.
It's not in fact what you did in this case.
I did not, and that is the second alternative submission that I made.
I mean, in this case, you relied upon
Yes.
the power under Rule 5
I
of
did.
the rules. Do you need to take us to Rule 5 of the rules?
Yes, I'll take you to that rule now. So assuming that I'm wrong.
Yes, but I'm just pointing out
Yes.
that your document at page 142 of the
Yes.
core bundle has a
Yes.
different route to this.
Yes. It does.
I mean, it might have been a very strong application, but you did
Yes.
make it. Do we have the actual application form? We don't.
There wasn't an application form.
There wasn't an application
Yes.
form. It was an application in the form of supplementary grounds of appeal themselves,
Yes.
and a covering email.
Yes. Yes. Now, if you wish to see Rule 5, it is page 13 of the authorities bundle, tab 3. Well, it does not concern amendment to the grounds, but Rule 5 concerns general case management powers, and sub-rule 3C allows the Upper Tribunal to permit a party to amend a document. Now, if permission is granted and the notice of appeal is served on the respondent, an appellant needs permission of the Upper Tribunal to amend the grounds, so to introduce a new ground. But no such permission is needed before service of the notice of appeal. But if I'm wrong about it, I did make an application to the Upper Tribunal to grant us permission to amend the grounds. Now, that application was before the Upper Tribunal, but wasn't considered by the judge, and therefore, even if the court takes the view that the supplementary grounds were out of time, what I say in response is that they were out of time, but with an application to allow
And the breach of natural justice is not having that application considered.
Yes.
Yeah.
But this is the position as a matter of law, that permission is not required to add new grounds before a decision is taken in the notice.
What's the point then in the rule that you should provide your grounds in 14 days? I mean, the rule might just say provide the grounds anytime you want.
Yes. But
and is that's the consequence of your first submission, isn't it?
Yes, but this is no different from the CPR, which says that, well, you must provide grounds or pleadings or statement of case with the claim form.
But it's not just, I mean, the interests that are involved here are not just the interests of the parties, they're also the interests of the community through the efficient running of the system. And if you can simply feed grounds of appeal, I mean, to take a ridiculous case, on a daily basis, this is my Monday ground of appeal, and I've now thought of another one for Tuesday. Now, I mean, no court office could operate.
Now, these are, with respect to submissions that I made for the Secretary of State in Sampaio, the judgment that I've taken you to.
Yes.
Well, when you look at if you look at the analysis, you'll see that these were the submissions that were made against the idea that a party may amend the grounds prior to service. But the court said that, well, no, because a party who is not served wouldn't even know what is going on. It makes no difference to that party, and therefore you're entitled to amend your grounds without seeking permission. Now, if the point is troubling you as to the provision in the rules that says that the notice of appeal should be accompanied by the grounds of appeal, then that's no difference. That's no different from Part 4 of the rules that apply to judicial review proceedings. I mean, of course, you need to plead your case in the claim form. You cannot simply file the claim form. And you need to submit grounds of judicial review with the claim form. But the point is that you can amend.
So you're saying that the same point would have been good in SPY-U?
Yes. So this is the first point made in the respondent's notice. The second point is one of substance. Can I just take you to Miller & Friend's skeleton argument?
Right, are we now on, have you moved to respondent's notice 2?
Yes.
Yes, thank you.
This is where Miller & Friend says that the judge was right to conclude that the finding that there is no family life is justified. So page 43 of the bundle, you have Miller & Friend's skeleton argument. Can I take you to page 59 of the bundle, where you'll see a heading, FTT contains no arguable error of law ground 2. And you'll see that Miller & Friend makes a submission that the appellant's case is that the judge was wrong to find that there was no error, and Miller & Friend then makes submissions based on case law as to the decisions made below. Now, those submissions, with respect, advance a case as if it is actually an appeal before the Upper Tribunal from the first year tribunal's decision. Now, I need not to persuade the court that my appeal my appeal from the first year tribunal to the Upper Tribunal is well founded, and it will succeed. All I need to demonstrate in my submission is that my grounds are not hopeless. There is a prospect of a different outcome. There is at least a real prospect of success.
Yeah, well, certainly I agree with that, but Mr. Justice Griffiths held that there wasn't.
Yes.
and he made various points, but I think his fundamental point was that even if this was family life, the proportionality exercise is the same.
Yes.
And was unimpeachable.
Yes. Now, just to address that very briefly.
Yes, I see. We had the same problem on Tuesday. We have a half-day listing.
Yes.
Nobody could accuse you of having not been succinct. This is your last point.
It is, yes.
Don't feel you've got to leave enough time for Ms. Taylor to finish by lunchtime, because you may be very succinct, Ms. Taylor, but we will certainly go over lunch if necessary.
I'm grateful.
Which it's likely to be, I think. Hopefully not by very much.
Very grateful.
It's become very focused.
Very grateful. Can I perhaps just to save time, take you to a couple of paragraphs in my skeleton argument rather than taking you to the authorities?
Yes.
Because what I've said about case law is uncontroversial. So paragraph 9 of my skeleton argument. It's my replacement skeleton. You may have it.
I brought it loose.
Yes.
Yes.
I referred you to Kugatis and Mubin. And what I've said at paragraph 9 is uncontroversial. I've taken that from paragraphs 44 and 46 of Mubin. So whether family life is engaged is a fact-sensitive inquiry. A careful assessment of all relevant facts is needed. Love and affection is not sufficient. There has to be something more. Normal emotional ties are usually not enough, and further elements of emotional or financial dependency are necessary. So, elements of emotional and financial dependency, but there is no need to prove exceptional dependency. It is the substance that matters. The existence of real, effective and committed support is an indicator of family life. Cohabitation is generally a strong pointer.
Can I just ask one factual question, which I think is in there somewhere? Your client is, or Dr. Alam is your client's uncle in the strict sense. I know that in some South Asian family terminology, uncle and aunt are often used very loosely, but
Yes.
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 Thank you.
Yes. So these are the principles. Now, Milan Friend cites the judgment of this court in Singh in her skeleton argument, but Singh is one of the authorities that was considered in Mubin. So what I've said at paragraph 9 is uncontroversial. Then paragraph 13, again, just to save time, you have Mubin in the bundle. So paragraphs 44 and 45 that you may need to look at. And the second authority, Milady Milords, that you look at is W.V. Uganda. This paragraph 13 of my skeleton, paragraph 22, again, what it says is uncontroversial, that the threshold for engagement of Article 8 is low. It's a very low threshold. Now, with these principles in mind, can I take you to the first year tribunal's decision? Starts at page 172 of the bundle. You'll see a heading, the appellant's case, at paragraph 6. And there is a summary at paragraph 6 to 9 of the appellant's evidence. You'll see that the appellant was a victim of domestic abuse and a victim of sexual abuse. And you'll see that she gave evidence as to how she became suicidal and made unsuccessful attempts to commit suicide. This is paragraph 9. and ultimately she was able to come to the UK with assistance of his uncle, Dr. Allen. Paragraph 10, so paragraphs 6 to 9.
Yes, I see one of her paternal uncles. So it's effectively says it's her father's brother.
Yes.
Yeah. Okay.
Quite a traumatic background. So she comes to the UK in 2014. That's like 11 years ago, 8 years when the decision was taken. Now, Dr. Allen has serious health issues. This is paragraph 10, and you'll see that the appellant has been looking after him as his full-time carer. So for 8 years or so, now 11 years, they live together. The appellant was Dr. Allen's full-time carer. There was a suitability issue that was resolved in the appellant's favor. And can I just take you straight to the Article 8 analysis? This is at page 180 of the bundle, paragraph 34. The judge accepts.
So the Article 8, I mean, what? Yes, I see. I'm just spelling it out. This has to be Article 8 outside the rules.
Yes.
Because although she's saying family life, it's not the kind of family life that's dealt with by Appendix FM.
Right.
Yeah. Okay, got that.
Yes. So paragraph 34, which is at page 180 of the bundle. Now this is where the judge makes a series of findings. First, that the appellant and Dr. Alam have lived together for 8 years. So there is cohabitation. Mubin says it's a strong indicator. Dr. Alam is dependent on the appellant. The appellant is Dr. Alam's main carer. The appellant assists Dr. Alam with his personal needs, including showering and so on. Fourth, Dr. Alam needs the appellant's physical and emotional support. He needs that support, the judge said. Fifth, there is a strong bond, strong ties between the appellant and Dr. Alam. There is emotional dependency between Dr. Alam and the appellant. And Dr. Alam's health may deteriorate on separation from the appellant. Now, if you apply the approach in Mubin, the only conclusion open to the judge was to find that family life limb of Article 8 is engaged. But the judge says that family life limb is not engaged at paragraph 34. I do not find that they have formed a family life together, but I do accept there are close ties between them. That finding is perverse. It wasn't open to the judge on the evidence of the findings of fact. But in any event, the finding is inadequately reasoned. The judge has not explained why the judge concludes that there is no family life.
At an earlier stage, you made the interesting point about the different focus of a private life inquiry and a family life inquiry.
Yes.
I'm interested in the substance behind that point. And if, accepting your that you've made a submission about the adequacy of reasoning, but in some senses, paragraphs 34 and 35, which are the core of this part of the argument, have a greater focus on Dr. Allen than they do on your client.
Yes, so at 34 and 35, the judge is making findings of fact, but is saying that family life limb is not engaged. What follows from paragraph 36 onwards is consideration of the private life claim.
Yes, but if you go to 39, for example,
Yes.
um,
Yes.
which is the last paragraph,
Yes.
the judge then picks up the baton,
Yes.
where he appears to be.
Yes.
Well, one might have thought that this was a claim by Dr. Allen, not by your client. So I'm not seeing at the moment what the content of your
Submission.
well-focused submission in relation to the difference between private and family.
Yes.
Dr. Allen is absolutely front and centre of this decision, isn't he?
I will explain why that is material. Now, if you look at paragraph, so 34 and 35 are findings.
Yes.
Look at 36. Now, this is where the judge quotes section 117B of the 2014 Act. Now, that section says, and this was really at the forefront of the judge's mind, at subsection 5, little weight should be given to a private life established by a person at a time when the person's immigration status is precarious. Now, that applies only to the private life limb, not to the family life limb. So the judge is saying that I'm only considering the private life claim and starting with the proposition that I'm going to attach little weight to the private life because your immigration status is precarious. Now that little weight provision does not apply to family life. Now this is then reinforced at paragraph 38, where the judge refers to the judgment of the Supreme Court in Rupiah, which is about the little weight provision in section 117B5. The judge is proceeding on the basis that he is obliged to attach little weight to the appellant's private life. Now, if the judge was conducting a proportionality assessment on the basis that the family life limb was engaged, then the little weight provisions would not apply.
That's true, but we heard an appeal earlier this week in which we were referred to case law that suggests that a similar approach applies to family life, which is strengthened and established when someone's status is precarious.
Yes. So if you heard an appeal, then you of course
the boss will be able to tell you all about it.
But the point is there is case law that suggests that a similar approach should apply to family life.
Absolutely. Now you heard the appeal. That means that someone must have granted permission, believing that the point was arguable.
Yeah.
Now I do not dispute that there are authorities pointing to the other side.
In fact, I granted permission.
Yes. Okay. You granted permission. Yes. So. Yeah, absolutely. So there are authorities pointing to a different direction. But these are matters for a full hearing at the Upper Tribunal, an appeal hearing at the Upper Tribunal. I have established in my respective submission that there is an error of law at paragraphs 34 and 35. Now, if the Secretary of State wants to contend that the error is not material to the outcome, then this is a point for the hearing.
But where do we, I mean, it may be here. Unfortunately, this is not a searchable bundle that I've been given, but I'm looking to see where in paragraph 39, for example.
Yes.
I mean, the judge has quoted from Rupiah at 2 points.
Yes.
And he refers to weight.
Yes.
And he refers, for example, to factors about Dr. Allen's health as attracting some weight.
Yes.
But not overwhelming.
No.
So, I mean, I'm just trying to knit together. I appreciate that it's cheek by jowl with the direction from Rupiah, but where does the judge, as it were, say I'm required to attach little weight?
Yes, this is paragraph 36, where the judge said that in considering the public interest under Article 8, I have kept in mind the case I have considered and the provisions of section 117B. So the judge is saying that I have these provisions in mind, which includes the little weight provision.
Yes.
And which includes Rupiah. So the judge was proceeding on the basis that little weight is to be given to private life. Now,
well, what should he have done instead? I mean, your client has been precarious throughout the period of the creation of this relationship.
Yes. So
I mean, he was bound to take that into account, wasn't he?
yeah. So Parliament, when enacting Section 107B, was careful enough, in my respective submission, to make it clear that little weight provisions apply only to private life claims. If a person has lived here unlawfully or the immigration status is precarious, that person is responsible for it. But where there is emotional dependency with a settled person, then Parliament has not said that the family life
No, but in the practical sense, I understand that, I mean, not everything can be decided on the basis of what's written down on a piece of paper. You've got to look at the real situation. But in this case, Dr. Allen knew that the relationship was based upon his niece not having the right to be here. And so he was implicated in the same way as your client is implicated. So what complaint can there be if the judge holds that in mind when making the decision about the weight to be given? I mean, what possible complaint can there be to about that being one of the foreground features of the situation?
Lord, I took you anticipating that concern to the earlier part of the decision where the background evidence is summarized, the evidence that the judge seemed to have accepted. The Home Secretary took no issue with that, or at least takes no issue with that now. So this is an appellant who was a victim of domestic violence and domestic abuse. She was suicidal. There was evidence about attempted rapes, and she fled the country essentially with assistance of relatives.
There was the 276, whatever it was. The middle part of the decision is all to do with whether she could get back.
No, that's not my point. I'm not saying that there are sort of very significant obstacles.
No, but you can't just pluck out one part of the history and then not the other.
No. What I'm saying with respect is that when assessing the issue of proportionality and what weight to attach to the family life, the judge would have had regard to that context. And it's possible for a judge to say that, well, I'm not going to attach little weight to family life in the circumstances of this particular case. Dr. Alam hasn't done anything wrong.
But you haven't resurrected, as part of your JR or as part of anything since then, the fact that the tribunal ought to have given much more weight to your client's very difficult history.
No.
That's gone.
No, that is, yes. But my complaint is that the judge proceeded on the wrong footing. If the judge had proceeded on the basis that family life limb of Article 8 was engaged, it is at least arguable that the outcome could have been different. I said I do with respect to the risk of repeating myself, submit that that all I need to establish is that my appeal would not be hopeless if there is an arguable error of law at paragraphs 34 and 35. Permission should be given. If the Secretary of State wants to argue that the error alleged is immaterial to the outcome, then that's the matter for the appeal hearing. Both sides will make full arguments, and the Upper Tribunal will make their decision. It wouldn't be, in my respect, submission appropriate to, if there is an error of law, to refuse permission. Now, I completely understand that paragraph 39 is troubling my lord, and that is for understandable reason. Now, you have my submission as to what is said at 36 and 38. Can I just make one final point about paragraph 39? That is a point that is in addition to the points that I've made. So this is where the judge says, I do not find that care and emotional needs of Dr. Allen outweigh the public interest. And he then repeats the phrase, his mental health and emotional problems do not trump the weight. Now, if family life limb of Article 8 is engaged, then Dr. Allen's right to family life is fully engaged. It's not simply his need for care, emotional needs. It is his right. It is his right to be with the appellant. Now, that right can be outweighed by public interest considerations, but that is his right, the judge has not made the assessment on that basis. The judge has not made an assessment on the basis that Dr. Alam's family life right is as engaged as the appellant's family life right limb. And that is, in my respective submission, an arguable error of law. And for these reasons, I submit that the judge below the High Court, insofar as the judge concluded that the appeal had no real prospect of success, that decision is wrong. You have my submission that the real question for the judge was whether it was arguable that the appeal has a real prospect of success.
But is there potentially a further point, which is that the focus of 39 is a narrow facet of Dr. Alam's position, but there isn't any real focus on the appellant's right to family life?
Yes, family life. I mean, this is. I'm grateful. This is Biaku Betts, obviously.
Yeah.
That one has to look at.
Because she's the appellant after all.
She is. Yes. She is. And as I respectfully submitted, the fundamental problem is that the judge made this assessment on the basis that family life limb was not engaged. There is a real possibility that the outcome could have been different if Article 8 was engaged. So unless I can assist you any further, these are my submissions. I'm very grateful for the patience.
No, thank you very much. Yes, Mr. Taylor.
In terms of structure, I will start with effectively my first ground, the respondent's notice point on the section 11A. So I will essentially follow the same structure as my learned friend, starting with that point, moving on to consider his first ground of appeal in terms of whether or not the judge applied the right standard below around arguability, and then turning to effectively the decision of the first tier tribunal and the upper tribunal. So in Respondent's Notice Ground 1, the Secretary of State maintains that the procedural defect here, the failure to place supplemental grounds of appeal before the upper tribunal, before they took the decision on permission to appeal, does not amount to a fundamental breach of the principles of natural justice, and therefore the Section 11A exemption is not engaged. I have 3 points to make initially around what it means to be a fundamental breach of the principles of natural justice. The source of that test, as this court recognized in LA, stems from what was described as the pre-anisminic excess of jurisdiction and denial of fundamental justice test, which was effectively, in part, the test adopted by the Court of Appeal and then rejected by the Supreme Court. But at both the Supreme Court level and at the Court of Appeal, in CART, both courts considered what that meant. So if I could ask my lords and my lady to turn up the bundle of authorities and start with, behind tab 4, the Supreme Court's decision in CART. And first, at page 93 of that bundle, paragraph 109, Lord Dyson explains that this excess of jurisdiction and denial of fundamental justice test is an wholly exceptional collapse of fair procedure. And I'm just in the middle of the carryover paragraph of 109 on page 93, just above the first bullet point, bullet punch. So, describing something quite significant.
Sorry.
But isn't it quite significant, or isn't it a wholly exceptional collapse if the grounds are not fully before the decision maker?
Well, in my submission, not in this case, and I'll come on to that next.
All right.
But for
Okay.
essentially,
And with that's the test, right?
yeah, that's the test. And looking to CART in the Court of Appeal, which I handed up. It was provided late, so I hope you have that before you. But the point is at paragraph, well, if we start with paragraph 4.
Sorry, where are we now?
It's a loose case that was hopefully placed on your
CART
desk.
in the Court of Appeal, thank you.
CART in the Court of Appeal. Paragraph 4, it is common ground that what we're talking about here is the denial of the right to a fair hearing. At paragraph 26, of middle of the page, sorry, paragraph 26, middle of the paragraph, some fundamentally unfair procedural step. And then at 37, Lord Justice Sedley gives an example of what that would be.
Is this Lord Justice Sedley? I thought it was Lord Justice Laws.
Sorry, I think it was.
It is, no, you're right, it is.
It was the decision of Laws was in the Lord Justice Laws was in the divisional court, and that was the kind of beautiful.
Yep, so sorry, yes. Yep. Sorry, you're quite right.
Where were you taking us to now?
Paragraph 37, if I could just invite my lords and my lady to cast your eye over the example given there. Member of the Upper Tribunal sitting when ineligible or subject to a conflict of interest or extremely unfair hearing, and it would be rare. And then in the explanatory notes, which are behind in the authorities bundle behind tab 2 on page 5. It's paragraph 105. And the notes say that section 4C covers circumstances where the Upper Tribunal acted in bad faith or in such a procedurally defective way as amounts to fundamental breaches of the principles of natural justice. Fundamental breaches of the principles of natural justice include such things as the decision being affected by bias or corruption, and all these scenarios would be very unlikely to arise. So, in my submission is that the test for a fundamental breach of the principles of natural justice reflects a high standard or hurdle to establish the requisite level of procedural irregularity. And I adopt the definition of Mr. Justice Sinai in Oceana, which my learned friend pushed back on at paragraph 33.
I'm not understanding this because we've now got, arising from this is a statutory provision.
Yes.
Which includes, which removes the bar in cases where there isn't a valid application, where there isn't, the tribunal isn't properly constituted. So the sort of things that were being discussed in CART, or the rare case of acting in bad faith.
Yes.
Again, but then or in such a procedurally defective way. So I'm not.
Yes.
Your suggestion is that what is to be considered as a fundamental breach of natural justice is to be interpreted in the context of these other aberrations?
No, I'm illustrating that these are all high hurdles. So it would be that.
Well, I think you're agreeing with what I've said.
I think that's probably right. Yes.
Okay, high hurdle.
High hurdle.
You had 3 points. What was the next one?
So high hurdle is the second point.
Oh, so what was the first?
The first was the source of the test.
Oh, I see. Okay.
And high hurdle is the second, and essentially I adopt the definition or the description in Oceana behind tab.
Yes, well, we were taken to that.
You were taken to that, so you have that. And that, in what was said, something that identifies a failure in the process which is so grave as to rob the process of any legitimacy, and that is a substantial hurdle. And that's the point I adopt.
Well, speaking for myself, I don't like all these glossing phrases. We've got quite an elaborate phrase in the statute introducing phrases about legitimacy. It's just fuzzies the whole thing up.
And there's no real support for bias or corruption in the statutory language, which I must say provisionally seems to me to be wider than bias or corruption.
Bias or corruption would surely be bad faith.
Yes, yes. A procedurally defective breach of, I mean, the main principle of natural justice which would be engaged is audi alteram partem, rather than anything to do with bias.
Yes.
To me.
I mean, suppose, test it this way, suppose the example I put to Mr. Malik, that from the start there had been 5 grounds of appeal, but the second page was lost by the court administration, so the judge only dealt with 3. I would have thought that was an obvious case of a fundamental breach of the principles of natural justice.
I think it does depend, as the point my lord made, that it depends on the context. Well, what if those pages 2 or 3, what if the 4th and 5th grounds simply reiterated the first 2 points?
Oh, well, I dare say that would be a different point. But, okay, let me refine the example. There are the second page, the grounds of the second page are substantive, separate, not vexatious grounds.
Yes.
Would that be a fundamental breach of the principles of natural justice if the judge, considering the application for permission, refused, not having been aware that those grounds were being advanced?
I think I have to accept that.
Yes.
But I think my case is that, I think the short point I'm trying to make here is simply that it's a substantial hurdle. And that in assessing whether or not the hurdle has been crossed, one must take, and this is my third point, the holistic approach. And that brings in the substance of the grounds of appeals in this type of example here. It also brings in this case, time and the availability of another route. So those are 3 factors which I say distance this case from the stark example given by my lord around, a failure to take into account 2 properly formed grounds of appeal.
Okay.
So, coming on to those 3 distinctions in this case. The first point I have is that there was no material infringement of that right. This is effectively the out of time point, because the appellant had the opportunity to raise the arguments to the Upper Tribunal that they wished to. There were 2 sets of appeal grounds, first to the first tier tribunal and then to the Upper Tribunal, settled by experienced counsel. And so this is in and of itself sufficient to meet the requirement that the claimant be given an opportunity, a reasonable opportunity to be heard by an independent tribunal. The error arose with respective grounds of appeal which were additional and late, as has been acknowledged, not by days but by months.
Well, it's not acknowledged that they're late. Mr. Malik's
I think I was
headline cases that they can come any time they want.
Yes, and I'm sorry, but I meant the time frame, the months point. But in
that
terms
doesn't really matter, does it? They got lost by the office. Does it matter whether they were lost they were lost, a bit was lost of papers when first submitted, or a bit was lost of papers that submitted later? If there's no breach of rules, I can't see how it makes any difference.
Well, first of all, I do not accept his interpretation of wasif, and I'll come on to that. But I don't think we have any, if the Upper Tribunal had made the decision on the same day, on the 4th, and so the grounds of appeal had come in after, there would be no doubt that there was no fundamental breach.
Of course.
The Upper Tribunal was
because the case that he had wanted to make, he'd had the opportunity to make it, and he had second thoughts.
Well,
but why should the accident that the tribunal took quite a long time to get to it deprive him of the argument that it was unfair?
Well, I think I rely on that factor, that it was rather, a fundamental breach can't turn on whether or not whether or not something is a fundamental breach can't turn on effectively the date the tribunal makes the decision. The only expectation the appellant had was that the Upper Tribunal would consider the grounds of appeal which were before it, i.e. those that were lodged with the notice of appeal on time. Because that was, at any point, once that 14 days had passed and he had lodged that appeal, she had lodged that appeal, that was what was before the Upper Tribunal to consider. At any point, the Upper Tribunal could have considered those grounds of appeal.
Right,
And so therefore there's no expectation.
Since the decision adverse to her was made, that by the time we're talking about November 2022, that she'd had 2.5 years to make her case. And she'd made it through various iterations at various times, and that was plenty, is your case.
Yes, and in my case, that she can't have had the same expectation with respect to grounds that were filed out of time and late, knowing that at any point the Upper Tribunal could have taken a decision, as she would have with respect to her original grounds.
Okay, but you've got to make good the fact that it was out of time.
Yes. So I'm just conscious of the time. Are you? It's quite happy for me to continue on this.
No, I'd assume we just rise at 1 in the usual way. So you've got 5 minutes. If you told me, but I'm sure you're not going to tell me that you were going to finish in 20 minutes, we'd go on till 1:15. But I don't.
I think I probably have a half an hour.
Yeah, well, fine. In that case,
I'm grateful.
We'll rise at 1.
So the Wasif was a different type of case. That was a case about judicial review.
So which
This was the case my learned friend. I'm sorry, not really. Safia. That was the case my learned friend.
Spy you. Yep.
My apologies. It's behind tab 13.
Yep.
And this is the case on which my learned friend relies.
Yes.
To show that
It's changed to. I don't mean about Mr. Malik personally. It's changed for counsel to rely on cases which they lost. But
yes, well, Mr. Malik's in most of the cases, so
yes, exactly.
That's the difficulty he has. So here, this was a case about judicial review. And it was a case about when you can amend effectively your pleading, your claim form for judicial review.
Yes.
There is a specific procedure which applies in the CPR on which reliance was placed. And in that context, it makes sense that up until the point the papers are served, you have a right to amend. But the context of an appeal before the Court of Appeal is a very different context.
So Court of Appeal, you mean
Upper Tribunal
Upper
appeals.
Tribunal in
Yes.
appellate
My
capacity.
apologies.
Yep. Yeah.
Your headline submission is that SPI doesn't apply.
Doesn't assist. It may not ultimately get me very far, because I say the route that my learned friend originally adopted, in which he made an application under Tribunal Rule 5 to amend his grounds, if those had been placed before the tribunal in time, before the decision was taken, it seems to me quite likely that that application would have been granted. There would have been nothing pointing the other way. But what I'm saying is there is a difference between the strong submission that my learned friend makes, that there is a right to amend, as opposed to a procedural process that must be followed by way of application, where unless there is a good reason not to, the amendment would be granted. So that's the distinction I'm making. It seems to me that one point which weighs in favor of the argument I've advanced is that unlike a JR, where you're amending your statement of fact, you amend your statement of facts and grounds, and nothing will happen until the respondent's notice is filed, and then the matter goes before the court for the question of permission. Here you have effectively a live application which could be decided at any time. So the distinction I'm inviting the court to adopt is that while there wasn't a right to amend, the amendment needed to be made pursuant to Rule 5, I fully accept realistically that if those papers had been linked, I can see no reason why the Upper Tribunal judge wouldn't have granted that application. That may be different in some cases if there's an extremely lengthy period, but here it seems quite straightforward.
Okay. Can I just ask this? Do you accept Mr. Mallett's point, which seems well founded on the basis of LA and the wording of the rules itself, that in fact at this stage, what Mr. Justice Griffiths was doing, what we've got therefore practice to do, is to decide whether it is arguable that there is a procedural defect of the necessary kind. It's not for us to decide that definitively.
Yes, I think I accept the position as was set out in LA, which was that...
Whether it's a disputable question.
Yes. Here, I say that I think in LA the language, a party needs to show a genuinely disputable question that the exception applies, and that's for your note at 38.
Well, we know that, yeah.
So, I mean, my submission is that there is no genuinely disputable question given the high standard of a
that's fine. No. So I just want to be clear, because your position is not only that you're right, but that you are unarguably right on this aspect. Yeah. Well, let's sit again at 2:00. Thank you.